Good afternoon. Another March afternoon. At this time, we are not quite sure whether it's winter or it's summer, but welcome. Welcome to another edition of the AJTP and IADTCP webinar. Actually, what it is another opportunity for us to learn from a number of experts and for us to share ideas. As you know, this has been Mental Health Court Month, and this is the last in a series of 3. And today's conversation is about mental health courts. It's going to be a judicial roundtable. I'm looking forward to having a conversation with some judges. As you know, we love to engage with you during this process. And so there's a Q&A function that you see. Please feel free to send in your questions at the end of our conversation. Kim Briggs is going to guide us by having us answer your questions. The panelists are reminded to please mute their microphones and when they're not speaking, and then put them back on when they are speaking. Now, these are judges, but the views of these judges are their own. They are not ours. And so I have to say that the AJTP and the IADTC does not necessarily subscribe to those views. However, we expect it to be very informative, and we are very pleased that you can join us today. A recorded version of this webinar will be available. It will be available on the website in a few days. And I'd like to thank our organizing committee. We have Kim Briggs, we have Erin Smith, Andre Rivard, Jennifer Graham, myself. This is the group of people who try and bring these webinars every so often, and we are grateful to them for their work in this particular regard. And as always, what I've been doing is I've been sort of waiting to make sure that we have enough people who are part of, who have joined us at this point. I see that we have quite a few participants have joined us. And so at this time, it is quite appropriate to do one of the most important things for today before we hear from our experts, the land acknowledgement. And for that, Andre Ribard will do the land acknowledgement.
Thank you. Thank you very much, Your Honor. As you know, it's important to this group to acknowledge the lands on which we meet. We're all gathered here remotely, virtually, from different corners of the province or country. But it's important that we acknowledge that we're meeting on Aboriginal land. It's been inhabited by Indigenous peoples from the beginning. As settlers, on behalf of this group, we're very grateful for the opportunity to meet here. We thank the generations of people who have taken care of this land for thousands of years. Long before today, there have been Aboriginal peoples that have been stewards of the land. And I'm mindful of particularly the Anishinaabe, the Huron-Wendat, the Haudenosaunee, Ojibwe, Chippewa cultures, the land that is home to the Métis, and most recently, the Mississaugas of the Credit First Nation, or the direct descendants of the Mississaugas of the Credit here in Peel. We recognize and we deeply appreciate the historic connections to the land. We recognize the contributions of the Métis, Inuit, Indigenous peoples that they've made in both shaping and strengthening our community, the province, and the country as a whole. It's important that we recognize that the contributions made by Indigenous peoples must be clearly and overtly connected to the collective commitment that we make if we're going to make this promise of truth and reconciliation real and meaningful and authentic, particularly as we bring justice for the lives lost in residential schools, as well as the murdered and missing Indigenous women and girls across our country. With that, I'll turn it back to you, Your Honor, for an introduction of our panelists. Thank you.
Thank you very much. Thank you very much. And now I have great pleasure that I am going to introduce the judges who I'm going to have the privilege of having a conversation with today. And one of the mistakes I made was I asked them to send me a summary of themselves. And what that meant is that both of them, all of them have left out many of their accomplishments. But I shall introduce them in the manner in which they've asked me to do it. Justice Richard Schneider was appointed to the bench in 2000 And he was one of the organizers of the first mental health court in North America. And currently he's seconded to chair the Ontario Review Board, and this happened in 2012. He's the author of many, many, many books. He's a psychiatrist, trained as a psychiatrist, as a lawyer, a judge. And also Justice Glenn Donald was appointed to the Ontario Court of Justice in 2018 to preside in St. Thomas, where at that time, then Assistant Crown Attorney Greg Sigurdsson was an Assistant Crown Attorney. Justice Donald was called to the bar in 2002, and he was a defense lawyer who spent a lot of time defending police officers. And his experiences doing this made it plain that mental health issues do not discriminate with respect to the impacts of that. At that time, there was a mental health court that was operating in St. Thomas when Justice Donald arrived. He took over the court in 2019. And what is most impressive is the fact that despite the interruptions of the pandemic, he made some adjustments and kept the court going through the pandemic without interruption. And Justice Greg Sigurdsson started his career in the Ontario government at the age of 18 years. And he was a correctional worker in a maximum security institution, no less. And he also served as a social worker at the London Psychiatric Hospital. And he also worked as the senior officer in charge at the Child and Parent Resource Institute, which is a government-operated children's mental health facility. Justice Sigurdsson was the prosecutor responsible for the mental health court in St. Thomas. And at that time, he had the privilege of appearing before Justice Donald, who is the co-panelist here. Justice Sigurdsson is one of the designated judges who presides in both the mental health and drug treatment courts in Kitchener. So, Your Honors, you're giving me permission, and I thank you very much to call you by your first names, and I intend to use it. So thank you so very much. Now, this is my first question. And one of the things that really, I think you need to explain. We talk about mental health. Why are legal experts interfering in an area that is the domain of mental health practitioners? After all, you guys, with the signal of Justice Schneider, who is actually a trained psychiatrist, I mean, most of you guys were not trained in that area, right? And why do we even need mental health courts in the first place? So Craig, do you want to start with that?
Absolutely. Thanks very much, Kofi. I'll maybe start with the second question first of why do we even need mental health courts in the first place? And I'm going to address that question by talking about some statistics I was able to pull off the internet last night. And I'll start by looking at the prevalence of mental health in the Canadian population. And I was quite surprised by the statistics I was able to find. And what I learned is that in any given year, 1 in 5 Canadians experience a mental health concern. By the time Canadians reach 40 years of age, 1 in 2 have or have had a mental illness. And the other thing I discovered from CAMH is that the disease burden of mental illness and substance use in Ontario is 1.5 times higher than all cancers put together and more than 7 times that of all infectious diseases. So it's huge. When I zero in on the statistics involving mental health and those involved with the criminal justice system, as summarized in 2021 by the Mental Health Commission of Canada, what I learned is this. The rate of mental health problems and illnesses among people involved with the criminal justice system is substantially higher than the general population, a rate that has been worsening over time, so much so that Health Canada identified mental health and the criminal justice system as a renewed area of focus in 2021. And what they said is that 73% of a subset of the men in the criminal justice system met the criteria for a mental disorder or a substance use disorder. What they also said is that 79% of a subset of the women in the criminal justice system met the criteria for a mental or substance use disorder. So the numbers are staggering. When you drill down even further to look at some of the specific priority populations within the criminal justice system, what you find is that 83% of First Nations, Inuit, and Métis men in the criminal justice system met the criteria for a mental disorder. And then 95% of First Nations, Inuit, and Métis women in the criminal justice system met the criteria for a mental disorder. So I would suggest that the statistics themselves make a compelling case for the need for mental health courts, given the sheer number of individuals appearing in the criminal court whose criminality is motivated by or interrelated with significant mental health and or substance abuse issues. And we also can't forget that these folks come from our community. There are parents, sisters, dads, kids, neighbors. So it makes sense that the most effective response to their complex presentation comes through a partnership with the community, which I see as the real value of the therapeutic court. Now, I'll address Kofi's first question, which is really, why are legal experts interfering with the domain of mental health experts? And I don't characterize our work as an interference, but rather I see it as a partnership. In my experience, when both legal and mental health professionals come together as a cohesive team and wrap around the client, providing resources, support, encouragement, accountability, that partnership is what creates the very best outcomes. And quite frankly, the issues are too complex for the legal system to tackle by itself. The tools, as everyone knows, in the criminal code are fixed and they're somewhat blunt. We have probation, we have jail, we have conditional sentences, to name a few. And these are traditional court approaches that often don't have the creativity and the flexibility that's required to effectively tackle the complex presentations that we see in 2022, especially when we consider the prevalent comorbidity of substance use with mental health concerns. So I would suggest that to get the very best result, not only for the client, but also for the community, we have to work together as a team. We have to work together in partnership. I'll speak for a little bit, Kofi, about the court that we developed in St. Thomas. And I think that was a great example of that sort of mental health and legal partnership that I'm talking about. So it was a situation where we had all of the key community agencies in town, from mental health to addiction services to services for those with brain injuries, as well as developmental services. All of those agencies came together to become involved in the planning for the court and indicated their commitment to serving our clients, not only at the table, but also in writing. We actually got a written commitment from each of the agencies. When I look at the court itself, the team met before the court for a couple of hours to review each person individually, to discuss their strengths, their concerns, and also talk about future therapeutic planning. And one of the really unique aspects of the St. Thomas Court is that even the sentencing decisions were cultivated following what was often quite a lively discussion or debate between the Crown and the two therapeutic court advocates, one of whom was Professor Kim Briggs, who is well known in this circle. Every decision and every process that we had in place exemplified the notion of a partnership between the court and the community. It also aimed to minimize the traditional power differential between legal professionals and mental health advocates. And I'm happy to say that the approach worked. The final thing I'll say at this stage, Kofi, with respect to the court that we had in St. Thomas, is that we had a very unique approach to the graduation. And what we did in St. Thomas is the judge personally presented a graduation certificate and actually left the dais to be able to present the certificate to the graduate. And I'll never forget the first two graduates from the court. And those were both men who had been to the penitentiary, what we learned from both of those men is they had never really graduated from anything in their life. They'd never really successfully completed anything. Both of them also commented that they had never been in such close physical proximity to a judge, let alone actually shook a judge's hand. What I noticed as the Crown at the time is that there were tears in their eyes when they actually made it through the court successfully. And what I also found curious, even all these years later, is we never saw either of those men back in the court, even years later. So if we measure our work in criminal justice, as many people do, with an eye towards recidivism, they truly made it. They were success stories. So those are my thoughts, Kofi, with respect to both of those questions.
Yeah. Well, Glenn, Craig just described the court you presiding, right? Do you have any comment to that before I go to Richard?
Well, I do have some comments, Kofi. At risk of skipping ahead, the benefit that I had in when I got appointed and stepping into an already functioning mental health court was that there it was already functioning, although there were changes. I'm not actually sure, and Craig, if I have it wrong, you'll tell me, but I don't know that you and I ever actually overlapped in that court. I think that there was some changes going on. I was one of those changes, and I was going into a thing that I knew was working well, but I didn't know exactly how it was working or why it was working so well. And so I was part of a series of changes that was taking place. What I came to learn really quickly, though, Kofi, was that all of the people who were there were exactly as Craig described. They were involved in a partnership with the community, and I stepped into that partnership and had to find my own way. So I really had the benefit of work done by my predecessors to answer the question. But what I will say, though, Kofi, about my view of the importance of the mental health court, sort of philosophically speaking, is when I look at what the Supreme Court of Canada tells trial judges in Lacasse, how these things are to be highly individualized. In my view, mental health courts are a response to what the Supreme Court of Canada asks us to do. Take a subset of your sentencings, i.e. dealing with people with mental health issues, and highly individualize them. And that's how, in my view, mental health courts assist the community.
Yeah. Now, Richard. I mean, you were part of the group that founded the very first one. Any comments? Actually, Richard, you're muted.
Thanks, Kofi. I apologize. Yeah, I have a couple of comments just to come back and refocus on the question you asked originally. Why are legal experts interfering? And it's an excellent question. I take, though, Craig's point. I don't think the courts have been interfering. The courts have been left with a situation that needed a response. And diversion programs, mental health courts have been a response to the problem. You have to understand that the present system that we have is not one that was designed. It's one that evolved. After all, who would design a program to look after individuals with mental illness that involved police, lawyers, jails, judges, and courts rather than mental health professionals? It sounds counterintuitive, but unfortunately, we've found too many people due to a number of failures that we might talk about later, who've ended up before the courts, have attracted the attention of the constabulary as a result of untreated or undertreated mental disorders, and the court has had to find a solution. Because, as I think Craig mentioned, the court in its regular functioning is a blunt instrument, never specifically designed to solve matters of this sort. So through partnerships with existing agencies and new formed partnerships, we've been able to cobble together a system that we call diversion programs or mental health court to try to get these people back into mainstream civil mental health care where they actually belong. So I think that's all I would add to the comments of my colleagues.
Okay. Well, one of the things that you have all said is that this is a situation where persons who have facing some mental challenges or mental illness have committed offenses, right? And that is the main reason why the court is involved. Well, taking that into account, I mean, do you think it's appropriate that that some mental health courts require people to plead guilty? Is admission of guilt a necessity as a prerequisite for entering what may be called mental health court diversion, or entering a mental health court program? Richard?
I think as your question implies, the practice is variable across Canada, across North America, and many courts do require an admission of guilt or a plea of guilty to get in the front door. I personally disagree with that completely. I think it's and I come up with that answer looking at it through several different lenses. First of all, I think it's antithetical to the overall goal of decriminalizing mental illness. It's not necessary. Furthermore, at least in Ontario, as I understand the various courts, one does not need to be fit to stand trial in order to engage in a diversion program. So without canvassing that issue in respect of an individual who's clearly mentally unwell, I think it's problematic to require an admission of guilt or plea. The other problem, of course, is that to require a plea as an entrance ticket, if you will, is, well, some would say it's effectively extorting an admission of guilt, even in situations where the accused may have a viable defense. So it compromises, to my mind, the volitional aspect of the plea. I don't think that it's necessary in any way. So from my perspective, no, a guilty plea should not be the entrance ticket.
Well, Richard, what I'm going to do is that I'm going to ask you a series of questions and then allow Craig and Glenn to comment at large at any one they want to pick, right? I mean, because I think for each one of you, I'm going to have a rapid fire. So Richard, this is your rapid fire, right? So,
all right.
So how about this whole business of whether should there be penalties for failing to comply with a mental health diversion program?
Again, my unequivocal answer is no. Failures or inabilities to comply, or I think adhere is probably the better term, shouldn't be met with penalties, but rather with further support. Often individuals fail because of difficulties in getting around the city, attending at appointments they need to attend at. So our view, at least in Toronto, had always been to meet failures or difficulties in adherence with further support, tweak to the program, adjustment to reporting schedules, to try to make the program that's been devised for the individual a better fit. So that's been our response. So my answer to question 2 is no penalties.
Okay, so no penalties. Now how about admission? I mean, should there be restrictions on who can get in, and if there should be restrictions, on what basis should these restrictions exist?
Mm-hmm. Well, with respect to the diversion program aspect of the mental health court, as you know, Kofi, some mental health courts are really not much more than a diversion program. Ours in downtown Toronto does many other things. But with respect to diversion in Ontario, of course, the criminal code has been chunked into 3 sections: presumptively divertible, absolutely not, and discretionary in the middle, roughly correlating with the seriousness of the so-called index offense. So so right at the gate, you have some consideration with respect to the nature of the allegations. But assuming you get past that hurdle, all the court really is looking for is a logical nexus between the allegations and a mental disorder. We don't need crisp diagnoses. Often in the early days, it's unknown. but reason to believe that there's a logical nexus between the allegations before the court and a mental illness. With respect to restrictions, in very rare instances, and I think my colleagues have probably seen the same, counsel will try to jockey their clients into mental health court where there's a dubious sort of merit to the whole thing, because mental health courts are seen as a very soft place to land. And if they can get their client through the door, it is probably a very good thing. Having said that, though, our court in Toronto would err on the side of inclusion. In even more extreme cases, though, there are, as you might expect, instances where the individual, once they've agreed to participate, really demonstrate that they have no interest. They're not attending where they need to be attending. They're not cooperating with any of the supports that have been offered. And if after attempts to meet this failure with adjustments, it's quite clear that the accused is simply not interested, we'll invite them to rejoin the regular prosecutorial stream. But in general, restrictions, no, beyond those inherent in the nature of the allegations. So I'd let my colleagues go further with that one. If there's another rapid fire, I think.
Oh, yeah, because I was going to ask you. I mean, you talked about the fact that there's variations between different mental health courts, right? And the question is, should there be fixed programs? Should there be a fixed program for each court so that it's standardized across the board?
Yeah, well, some academic observers would argue that there should be a fixed program, fixed duration, fixed curriculum, if you will. And I mean, from a scientific data collection sort of perspective, I can see that social scientists or academic observers, I can see the merit to that. However, the individuals that come through our doors, they come through with problems that are both qualitatively and quantitatively different. So the nature of the program they need, the sorts of supports they need, and the duration for which they need them varies, depending on their personal circumstances. So the court in Toronto does not have a fixed curriculum, either with respect to the content or duration. Our court mental health workers assess the accused and tailor-make a program that they see as optimal for that person's needs. So while I understand the argument, the contrary argument, my view is no, there shouldn't be fixed programs.
All right. So my rapid fire for Richard has dealt with general eligibility criteria. I mean, we're just talking about criteria and stuff. Craig, do you have any comment? Any comment at all on anything that Richard has said?
Well, I agree with Richard Covey with respect to the comments that he's made. And when I think about the first question that he asked, should a guilty plea or an admission of guilt be a prerequisite for entry into a mental health court? If you look at a mental health court and understand that the court is there to try to assist people, that's the whole objective of the mental health court. Why do you need some sort of ticket to be able to get into it if we're there to try to help people and if we're there to try to ensure that they're not back before the court in the future? When we talk about penalties for failure to comply with diversion, again, I agree with Richard that a penalty really is not helpful. And in a lot of cases, it might be counter-therapeutic, because at the end of the day, we're there to help. And ultimately, if the person isn't able to comply with the diversion program expectations, they're going to get the ultimate penalty, which is what Richard was already talking about, which is removal from the stream and return to the regular court process. When we're talking about restricting admission, I agree that the court should be open to as many people as possible. Again, going back to that goal, the overarching goal of the mental health court, which is to assist people and to try to get them out of the system. With respect to fixed programming for mental health courts, I don't like anything that's too fixed or too rigid. I think we have to be flexible because, of course, the clients that we're serving are all very different, and it really isn't a one-size-fits-all approach. We have to be flexible. We have to be creative to be able to meet the unique needs that we're seeing in the court. So I always try, as a matter of philosophy, to move away from sort of rigid or fixed lines and try to embrace approaches that are a little bit more novel and flexible and hopefully creative. So those are my thoughts, Kofi, with respect to those questions.
How about you, Glenn?
I don't know that I can add much, Kofi. I agree with both of my colleagues on all of what they've said. You know, to my mind, the only thing that I maybe can meaningfully add is in terms of restricted admissions. Well, I'm all about agreeing to err on the side of inclusion. You know, as Craig said, when I arrived in St. Thomas, the graduation was a judge gets up and shakes the hand of the graduate. I mean, there are offenses that, from a victim standpoint, that may be a real unseemly look. So, but I mean, that the Crowns do such a good job at screening out the completely inappropriate cases. I also err on the side of inclusion. Can't add anything else, Kofi.
Well, why don't we just move on to the theme of optimizing mental health courts, how to make them better. Now, we don't have enough time to address all the issues. So I'm just going to, Glenn, I'm going to ask you a specific question. I mean, you know, and I'm just going to wrap it all in, right? You know, how do we create the right culture in mental health courts? I mean, do you need to have a certain type of personnel in those courts? Is ongoing training required? I mean, you know, those type of issues.
So I think that the personnel, the people in those courts are everything. And I'm not talking about me. I'm a bit player. I'm the community groups that are there, all of them, to my mind, they do all of the work, and I come into the work that they've done. As you already heard, I entered a court that was already functioning. There were some turnovers in people, and maybe my philosophical view wasn't necessarily shared by all of those who were already there. But I understood that what I needed to do was to be slow and steady with my approach, to find places where I could ask questions or make an inquiry about something that would maybe allow people to see my level of flexibility, because of course I was an unknown commodity too. So to my mind, the spirit of cooperation and partnership that Craig spoke about was evident. I just maybe wanted to expand things from where they were. So I worked with the community partners to establish the ground rules effectively in there. And I think once we all got to see each other work, everyone's level of expectations of each other adapted accordingly. And I take it, that's an ongoing process. People change, new people come, old people leave, and it's a continuously evolving thing. For me, what I've learned, I think, is that I can set the tone in there, and that once I've set the tone in there, new people coming in, whether it's a new duty council or a new crown or a new member of a community service agency, they can see what's being modeled for them by the others who are already in the operating court. I'm not sure if that answers the question, but that's my stab at it.
No, it does. Actually, one of the questions I was going to ask is that follow up is that do you think judges need training? And when I talk about judges, I'm talking about the judge, of course, but I talk about the prosecutor, the lawyers, you know, all the players, even the treatment providers. You know, I mean, do people need training to understand how to work collaboratively in this partnership?
It's hard to ever suggest that training is a bad thing. But in my view, much of that training can be done by observing. If you have a genuine interest in being a participant in these courts, that's such a great starting point that, in my view, going in and finding one that works well, maybe observing a few of them, is probably a great place to train. But no, I can't suggest that training for any participant wouldn't be a bad thing. Seems to me it would be a good thing.
A good thing. Greg?
Thanks, Kofi. I really can't add too much to what Glenn has already said. I agree with everything that he said. When we're thinking about some of the personal characteristics that folks should possess in a mental health court. I think it's absolutely critical to be patient. I think it's absolutely critical to be a very careful listener and to have a great deal of empathy for people's backgrounds and the various factors that have led them to the court in the first place. I think it's also important to have an approach and modify an approach that's trauma informed. Given the fact that so many of the folks that are appearing in the mental health court have a significant trauma history that really is the driving factor in so many of the cases as to why they've been charged criminally in the first place. So that's about the only thing that I would add. I absolutely agree with everything Glenn has said.
So I mean, Craig, I might as well stay with you. We've talked about the courts, we've talked about eligibility, we've sort of tried to explain some of the systems in place. What approaches are most effective with accused persons before a therapeutic court or mental health court?
Well, I think one's approach, Kofi, has to reflect the unique needs of the client that is before the court. And I think of what Virginia Satir said, and she's perhaps the most famous social worker who has ever practiced. And I think she got it right when she said we need to start where the client is at. And that's the best advice that I could give is we've got to recognize the uniqueness of the client and start where they are. I think we also have to listen and listen very, very carefully because, of course, listening and trying to understand, to try to put yourself in the person's shoes is really how you show that you care as a helping professional. You also have to have a decent memory or be able to take some pretty good notes of the key themes and the challenges that have arisen as a particular case makes its way through the system, because you want the client to know and understand that you value their uniqueness. I've always found in criminal justice that a strengths-based approach has the most merit. So one of the things that I've tried to do in Kitchener is to use the classic sort of sandwich style approach, where I try to start and end with a strength or something that's being done well, and then try to tackle a challenge in the middle. There also has to be an accountability component where needed. In my view, an approach that doesn't call someone to account or push them in an appropriate direction is not reflective of the unique circumstances of the people who appear in a criminal court. So I think it's important to demonstrate your caring and show that you're also willing, especially as a judge, to give difficult feedback and to try to implore clients to do better. And I think that many of the participants in a therapeutic court look to the judge to do so. So those are my thoughts with respect to some of the approaches that I found effective in the therapeutic court.
You know, let me ask you a question, because when you talk about strength-based, right, for a non-legal, for a legal professional who's not had any training in that particular area, right? What do you mean by strength-based approach? Can you give an example of a strength-based approach?
So a strength-based approach, Kofi, is trying to drill down to try to identify what the person is doing well, what's going on in their life. So are they meeting with the advocate on a regular basis? Are they trying to find housing? Are they coming to the court every single month as required for the check-in? So it's trying to identify the things that are going well in their life, the things that they're on top of, and then viewing those as potential areas that can expand into further areas of competence or further areas of strength. So that's what I mean by a strength-based approach. And it's kind of a unique way of looking at a situation, at least from the perspective of the criminal justice system, because so often our approach is focused in on negatives. That's the focus of the court. So we really have to kind of flip our thinking to be able to try to identify what's going well, what's actually working, what are the signs of stability that this person presents with, in the hopes that if we can identify that, it allows for a little bit of expansion. So we have sort of a positive outlook versus more of a challenge-based outlook.
So as you proceed and you identify the strengths of this particular person, you also, I expect, are also going to become aware of what their needs are, and you know, which could vary in so many ways. What role, Craig, do community agencies play in such a court?
Kofi, you've probably heard me say this a few times. I really see the court as a partnership. And I think of St. Thomas, I think of the work that's done in Kitchener. Those are the hallmarks of both of those courts, and that's what makes them really, really effective. So what you see is the community agencies working together cooperatively with the court. What you see is that information is freely being shared between the community and the legal professionals. And when I talk about free sharing of information, it's also important to advise the legal professionals as to what is confidential and what should not be shared in open court. I also see the community and the legal professionals sort of coming together and speaking with one voice and having a unified front. I think it's really important for everyone not to split, to use the classic phrase that's often used in the context of working with folks with personality disorders. I also think it's important for community agencies to give feedback openly to the legal professionals, because you are the experts when it comes to mental health. And the community agencies also know the client better than anyone. The court sees the person perhaps for 10 minutes every couple of weeks, but the community agencies are working with these folks, in some cases, several hours every single week. So don't hesitate to speak up and let us know what the client needs and how our system is able to best approach those unique needs. Because of course, sometimes people with legal training come to the table with a very distinctive approach to what's often seen as a criminal law problem. So we really count on the community agencies to be able to bring some freshness and creativity to the table in the hopes that we can come up with some novel solutions. So I really see the best courts as being a partnership between all of the participants at the table, Kofi.
All right. Richard, do you have a comment?
No, I agree with all of that. The only thing I might have added, and with respect to handling the accused in the courtroom, the mental health court is going to be a unique experience for most of the people who are in it. If they've been to courts before, and many have, they're very used to being ignored and dictated to. So I find that one of the key things to establish at the outset is a rapport with the accused, and that can start with the judge and work its way down. And that can start with, and it's counterintuitive for some judges, I know, but to let the accused person speak. They're so used to not being heard and being told to be quiet, ignored, as I was saying. But you find that if you let the accused person speak, they, while determined to get their voice heard, they usually don't go on for that long. But I think it's a very important way of cementing a relationship at the outset, and understanding that this process is going to be one that's more in the form of a dialogue than various professional people shuttling them around and dictating to them what needs to be done where and by whom. But other than that, no, I agree with everything I've heard from my colleagues.
Yeah. Glenn, what do you think?
I agree completely. Rapport to me is everything. And just like Richard was saying, it's important to recognize that some people don't get heard. It's also equally important to realize that some people are awfully anxious being there and don't have a whole lot to say. So figuring out quickly what the individual you're dealing with wishes more of, more listening, or more talking and more encouraging, I think is really important.
All right. All right. So Glenn, I'm going to stay with you. Let's talk about evidence. I mean, evidentiary issues, that's a whole thing. But you know, we've described, we now have a sense of the court, how the court functions. it looks like some flexibility is required. So the question is, when you're dealing with evidentiary issues, when are you flexible? When are you stringent? And when you're making your various mental health court orders, are there any factors that you take into account when you're deciding how to scrutinize the evidence here?
It's difficult to say that when you're in a courtroom where you're filled with knowledgeable participants, it makes a world of difference. Number one, what you end up with most often, very often, are requests for consent orders to be made. And obviously, when I know that people are knowledgeable and I'm used to working with them, and I'm inclined to make the orders that that are being requested of me. However, I'm also mindful that everyone makes mistakes. So when I'm being presented a draft order, even by the most knowledgeable person, depending on how it's laid out, I may have questions for them that are really designed to get people talking, to make sure that, if someone were to review the record, that what I'm assuming to have been done was actually been done. So that's my approach there. So I'm probably more flexible, but I still want to make sure that the I's have been dotted and that the T's have been crossed, because obviously the types of orders that can be made under Section 672, even in a mental health court, can have some dramatic impacts. And so I'm mindful that the law is never displaced by what is otherwise seen to be consent. Does that answer the question, Kofi? At least
it answers the question. And before I get Richard and Craig to get in, there's a question that I got that I want to actually read to you. It says, what considerations must the judge balance when deciding whether to order treatment aimed at helping an individual, juxtaposed with personal liberty to decline medical intervention?
So that's a really difficult question. And so thanks for whoever asked it. I hope that you're here today to hear my best efforts at an answer, but I view my role in these courts as that of a problem solver. And so what I try and do is to encourage people to do the things that are probably required of them. I mean, my ability to impose, to make treatment orders is so narrowly defined under the specific subsections of 672 that I'm not inclined to go to those, because they are such an intrusion on people's personal liberty that I worry that undoes the rapport that I'm otherwise trying to build. So it's a delicate balance, to be sure. Again, sort of dovetailing it with the first part of the question. To my mind, most often in these courts, the experts are so knowledgeable, the community service providers are so knowledgeable that they're also trying to work these things out through consents and through encouragement, than the drastic resort to the types of orders where I can force a treatment. I'll tell you though, bearing in mind my limited ability to make treatment orders, it's interesting. I know what the Supreme Court of Canada says as it relates to treatment orders forming part of probation orders, but there does seem to be some limited amount of flexibility on, for instance, a conditional sentence, if that's the appropriate sentence, to continue the kind of good work that started in a mental health court. So in my mind, I think the theme here from the beginning has been flexibility, and the flexibility continues to be there as much as it's legally allowed to me.
Richard?
I agree with all of that. I took the question to be more focused specifically on a 5-8 order made upon a verdict of unfit to stand trial. And my comments are limited to that fairly focused arena. I mean, clearly, Kofi, a treatment order is the most invasive order a court can make. There's strict evidentiary requirements. The hospital's consent is required. And you have to balance, there's a lot goes into the mix in deciding whether or not to make the order. In Toronto, treatment orders or applications for treatment orders are invariably made upon a verdict of unfit. And in my experience, and I've made probably hundreds of them, when an order is made, an accused will return to court. I bring them back at halfway through a 60-day treatment order. If I know the psychotropic medications are going to kick in and work, they'll work within 30 days. And typically at 30 days, they return with an opinion that the accused is fit. If a treatment order is not made and the unfit accused goes to the review board, it's typical for the accused to spend 6 months or more, a year perhaps, in the hands of the review board. The review board, well, not so much the review board doesn't make the orders, but the hospitals who have custody are left to deal with civil legislation in order to effect treatment. So from a liberty perspective, you're talking about typically 30 days versus 6 months or more of liberty being lost as a result of that verdict of unfit. It's a very tricky balance. You have to be concerned about bed days. An accused who receives a treatment order will spend 30 days getting fit typically, whereas one getting fit through the civil legislation can take 6 months or more, occupying a bed that could be used by several other accused who are in the queue. So it's a very tricky balance. There are lots of factors to consider. I always look at how long does this accused have to wait for a bed, because the hospital's consent is required. If the wait times are up at 5, 6, 7 weeks, that would make me more inclined to perhaps not make the order, because I can put them into a hospital otherwise without the hospital's consent. So it's a difficult area. I know that's probably not a very satisfactory answer, Kofi, but there are many things to consider.
I'm going to skip for a second because I noticed the time. We've got 2 questions to have. At least 2 questions are in the chat, and I noticed the time. There's something I want you all to get a chance to deal with, right? And this has to do with the theme of reducing pressure on mental health courts in the future. And I'm going to read this, and I'm going to take this to you, Richard, and then I'll go to Craig to comment. But two questions. I'm just going to put them in one. One is, what should the next generation of mental health courts look like? And then, what are the things we could change to ease the pressure upon the courts in this population? Right, and I'd like each of you to comment. Richard, if I could start with you, and then that'll be our last question for the day.
All right, I'll try to be pithy to give my colleagues a chance. I think the next generation of mental health courts should perhaps consider having a broader mandate, broader focus. It's very few individuals who come through our doors with a singular problem of untreated mental illness. There are various comorbidities, substance abuse issues, housing, unemployment, social assistance gone awry, identification lost, clothing missing, the list goes on and on and on. In the Yukon, they have what they call a wellness court. So perhaps it's time to consider merging these courts, the mental health courts, the drug courts, into, I can't come up with a great name, but some sort of helping court or wellness court. I like the term wellness court used in the Yukon. What we can do to ease the pressure upon the courts in dealing with this population in the future, I think inevitably has to come back with better investment in mainstream civil mental health care. To my mind, most forensic patients, that is patients that we have before us in the courts, most forensic patients could otherwise be described as failed civil patients. Most come through the courthouse doors with extensive civil mental health histories. Civil mental health system had them, they failed, and the accused unfortunately slips further downstream and into our hands, leaving the mental health courts and diversion programs to sort out what's best. So I'll just cut it short with that.
Okay, thank you, Craig.
I echo Kofi what Richard has said. I've often wondered, especially in 2022, when there's such comorbidity between substance use and mental health, the need to have a distinction between those two courts. So I love the idea of potentially considering a merger of both the drug treatment as well as the mental health courts into one, because just about every client that we see has both of those issues in common. In terms of addressing the second issue, what are the things we could do to try to ease the pressure on the courts in dealing with the population? One of the suggestions that I have is to look at more diversion and consider even moving the diversion farther ahead. And what I mean by that is to consider police diversion, perhaps along the lines of what's mandated under the Youth Criminal Justice Act with respect to individuals with mental health, substance use, and/or developmental challenges. So those are my thoughts, Kofi.
All right. Glenn?
Front end resources, to my mind, is the only thing that can ease the burden on the criminal justice system. I think that's what Richard's point primarily was about. In terms of what we could do better, evolutionary steps, to my mind, the pandemic has provided a bit of an evolutionary step. I've presided over that court in a hybrid fashion by Zoom, mostly. I know that I expect that's been better for mental health clients who have anxiety type issues to attend from the privacy of their own rooms in some stages with, of course, the assistance. So we are taking evolutionary steps, I think, Kofi.
Richard, Craig, and Glenn, it's been a pleasure having this conversation with you. We can't thank you enough. Thank you for doing this. And I'm just going to turn to Kim, perform some miracles.
Thank you, everyone. We are definitely running out of time here, but there are a few questions in the chat, so we'll see if we can get through one or two quickly. A question from Sarah. She asked about consistency, that we've talked a lot about how people are treated and the outcome of their court matters, but how can we ensure consistency across the province in a better way than maybe we do now? Glenn?
I was hoping you weren't going to pick me for that one, because I mean, I think what you've heard from us today is that that we each have a flexible approach. So in terms of consistency, if your measure of consistency is being met in these types of courts by a judge with a flexible approach, then I think that's important. But in terms of outcomes, I can't speak to consistency of outcomes. To my mind, everyone should be entitled to the outcome that the Supreme Court of Canada suggests they ought to be, which is that they're going to be treated like the highly individualized person that they are. And that's the best I can do with that answer in a short period of time, Kim.
Does anyone else have anything to add to that? Justice Schneider or Justice Egerton?
I agree. I agree with Glenn. I think consistency has to be at the level of treating each individual as an individual and trying to respond to them in a way that best addresses their specific needs. But as I was saying earlier, consistency, if what we're talking about there is consistency of programming and curriculum in these sorts of diversion schemes, for the reasons I indicated earlier, I'm not so sure that I'm a big fan of that type of consistency.
Anything from you, Craig?
Can't really add anything, Kim, beyond what Glenn and Richard have already shared.
I think we are out of time today. We are definitely pushing the limit as far as the clock goes. We have a final comment here from one of our participants who noted that people like you in the justice system are using your education, experience, and history towards supporting change. So all of us here today, thank you for joining us today. I'm sure everybody learned a lot, and it's really great to hear from you. I hope everybody has a nice day.
Thank you for having me.
Yes, pleasure to be included. Thank you very much.
Thanks
for
for the
organizing it, Kofi. Well done.
Thanks, everyone.
Take care.